Hello and welcome to our channel. Today we are exploring the intricacies of Benami Transactions Prohibition Act 1988, a pivotal law in India's fight against black money and property-related malpractices. We'll break down its key provision, historical background, and recent amendments to help you understand its significance. What is Benami Transaction? A Benami transaction involves purchasing or holding a property in someone else's name, while the actual financial contribution comes from another person. So the person in whose name the property is held is called the Benamidar, and the person who provides the consideration is the beneficial owner. So this practice is often used to conceal the identity of real owner and evade legal scrutiny. Such transactions are now illegal under Indian law, and both the Benamidar and the beneficial owner can face severe penalties. If you see the historical background, the concept of Benami transactions dates back to the 18th century in India. Initially, these transactions were recognized by judiciary, as seen in case of Gopi Krishna Gosain versus Gunga Perusur Gosain in 1854, where the Privy Council acknowledged their customary nature. However, over time, the need to curb such practices led to legislative action. In 1988, the Indian Parliament enacted the Benami Transactions Prohibition Act to prohibit such transactions and the right to recover property held benami. Key definitions under the Act. The Section 2 of the Act provides crucial definitions. Benami transaction. Any transaction where property is transferred to one person for a consideration paid by another person. This is called Benami transaction. So any transaction where property is transferred to one person for a consideration paid by another person. So Benamidar means a person in whose name the property is held. Who is beneficial owner? The person who provides the consideration for the property is the beneficial owner. These are the definitions. Understanding these definitions is essential to grasp the scope of the Act. Prohibition and legal provisions. So Section 3 of the Act prohibits Benami transactions, stating that no person shall enter into any Benami transaction. No person shall enter into any Benami transaction. Section 4 further prohibits the right to recover property held Benami. So meaning that the real owner cannot claim the property held in someone else's name. This is what Section 4 says. So these provisions aim to eliminate the practice of holding property in false names to evade legal responsibilities. So here doubts come whether there are any exceptions to this rule. Yes, the Act provides certain exceptions where transactions are not considered Benami, that is property held by member of HUF, Hindu undivided family, for the benefit of other members. And another exception, property held in a fiduciary capacity, such by a trustee or executor. This is another exception. Another exception, property held in the name of one's spouse or child, provided the consideration is paid from known sources. So these exceptions acknowledge genuine transactions within families and fiduciary relationships. There is amendment in 2016. The Act was amended to strengthen its provisions. The amendment introduced renaming the Act to the Prohibition of Benami Property Transaction Act, 1888. Prohibition of Benami Transaction. Prohibition of Benami Property Transaction Act, 1888. So, establishing authorities for enforcement, including initiating officer, approving authority, administrator, and adjudicating authority. So empowering these authorities to conduct inquiries, attach, and confiscate the Benami properties. So these all come through amendments. So the amendment significantly bolstered the government's ability to combat Benami transactions. So we'll come to the penalties and offences. Under the Amendment Act, engaging in a Benami transaction can lead to imprisonment for ranging from 1 year to 7 years and a fine up to 25% of the property's fair market value. Providing false information can result in an imprisonment from 6 months to 5 years. Engaging in Benami transaction 1 year to 7 years. Providing false information 6 months to 5 years. And fine up to 10% of the property fair market value in false information. These stringent penalties serve a deterrent against engaging in Benami transactions. So there are notable case laws. Several court cases have shaped the interpretation of the Act. In Gurlingappa versus Income Tax Officer, the Supreme Court held that the Benami transactions are illegal and income from such transactions is taxable in the hands of the real owner. In state of Maharashtra versus Ramachandra M. Kaniya, the court held that amended act has retrospective effect applying to transactions before the amendment. These judgments underscore the judiciary's stance against Benami transactions. So what is the conclusion? The Benami Transactions Prohibition Act 1988, along with its 2016 amendments, plays a crucial role in India's efforts to combat black money, black money and ensure transparency in property ownership. Understanding its provision helps individuals stay compliant and avoid severe penalties. Thank you for watching. If you found this video informative, please like, share, and subscribe to our channel, RR Corporates, and another channel, RR Legal Talks, for more legal insights. If you have any question, leave comment below. Thank you.